So without casting any aspersions on Justice Cole's interest, understanding, and good judicial sense, I must tell you that the counsel in this case was our speaker today, Akhil Sibal. Uh, he argued the case very persuasively, and we have with us a judgment that will determine which way the arts, how the arts are looked at for future. The he has spent Sibal has spent many years reflecting on the issues contained in the topic of today, which is art, obscenity, prescriptions, and parampara. I already see some artists here, dancers, dance scholars, and they will understand that these words have been chosen with great deliberation. Our discussant, Dr. Alka Pande, is well known to all. She's the driving force behind the Visual Arts Gallery and its success and its iconic position it has in the world of visual arts. I know Alka to be not just articulate, but also fearless in her speaking out what she believes in. And her deep knowledge on the spectrum of the arts, her PhD was in performing arts, allows her to move between genres. So I think today's discussion will be a very interesting one. I request all of you to please mute your mics. And in some cases, if you're planning to get up and all that, I suggest to you that you, what do you do to cameras? You turn off your cameras as well. Any questions that you might want to ask, please type into the chat box. Our plan is to have Mr. Sibal speak for the first 40 minutes, Dr. Pande speak for the next 15 minutes, and then we still have time for questions and answers. So welcome everybody, and a very warm welcome to you, Mr. Sibal and Dr. Pande. Thank you so much for taking time out of your busy schedules to join us in this. So, Mr. Sibal, you can unmute yourself, and we look forward to what you have to say.
First of all, let me thank Dr. Arshiya for putting together this wonderfully unique series on art and law, and for inviting me to be a part of it. I feel privileged to share this platform with her and with Alka ji, who has such a deep knowledge, understanding, and appreciation for Indian art and its history. And thank you to all of you who've taken the time out to come and listen to us. When we think of art, we think of freedom, freedom of thought, and freedom of creative expression. When we think of law, we tend to think of rules, of boundaries and controls. And the two seem somewhat rather antithetical to one another. So how and where do these two realms intersect? What's unique about this wonderful series is that it seeks to explore the boundaries of that intersection. And though this is the last session in the series, I want to take a few moments to share with you why this intersection is inevitable and where we find its foundation. So art is certainly a form of self-expression, but it's not always private expression. An artist shares her creations with society. And the moment she does that, her expression intersects with other members of society. And the moment that society comes into the picture, the realm of rules that govern members of that society and that embody a certain order to which the society subscribes are triggered. And part of that realm of societal regulation is the system of laws that governs that society. The charter of our independent country is our constitution, which is the fountainhead of the principles that govern our particular country. So when we look at our constitution, we find that the freedom of speech and expression is not an absolute right without restriction. The state is permitted to formulate laws which impose reasonable restrictions on the exercise of this right in order to serve certain larger societal interests that may justify a restriction of this right. Decency and morality are two such interests identified in our Constitution as being legitimate grounds on which to impose reasonable restrictions on the exercise of the right of freedom of speech and expression. Now, some people may question as to whether there should be any limit to freedom of expression. And some people may be under a mistaken impression that in other jurisdictions, other countries, there's absolute freedom of speech and expression. We tend to think that Western jurisdictions have absolute freedom of expression. But the minute you think a little more carefully, you realize that this freedom cannot be allowed absolutely. And no other jurisdiction does so either. For instance, should you have the freedom to falsely shout fire in a crowded cinema hall? Surely not. Should you be free to defame others on the basis of false facts? Should child pornography be permitted in the name of freedom? Surely not. But yes, the boundaries of that freedom may vary between countries and jurisdictions. So once we're past the issue of freedom of expression being absolute, you may next wonder whether the police and the courts should be the ones to decide whether a particular work of art violates that boundary. That's a fair question. Why them? And are they best equipped to do so? But let's consider who else it can be, if not them. If it's not the courts, surely it shouldn't be the government. Surely it shouldn't be parliament. And ultimately, if there is an issue to be decided on whether a boundary has been crossed or not, someone has to have the last word on the issue. And that has to rest in the structure that we have in our Constitution, our constitutional framework, with an independent court. And it cannot be allowed to rest with a majoritarian parliament or government. If your speech is consistent with majority speech, you don't need protection. The majority protects you. It's when your expression goes against the norm, when it challenges and questions the norm, that's when you need legal protection against the majority to protect your individual freedom. And only the courts can ensure that that freedom is upheld, because the government of the day, parliament of the day, is likely to represent the majority voice which you are going against. So they are not going to be the ones to protect you. It's protection that you need from them. And therefore, the judgment cannot be put in their hands. Now, the next issue. Isn't art subjective? And aren't notions of obscenity subjective? If yes, then how can there be an objective law to decide whether a particular work of art is obscene or not? The rest of my presentation is going to be an attempt to answer that query. But before that, I want to make just a few remarks about law and the practice of law. Most non-lawyers, when they think of law and lawyers, are not generally filled with complimentary thoughts. Talk of law seems dry and lifeless, in a sense, the opposite of art. Lawyers seem to speak a curious alien language of rhetoric, jargon, and unwieldy expressions that are difficult to digest. If you're having trouble sleeping, just start reading a law or statute passed by the legislature, and you will be blessed with instant deep sleep. But I want to share with you that although the law seems opaque and esoteric, inaccessible, filled with jargon, and it's true that lawyers are not always the most honest and professional gatekeepers of access to courts, but the law in its theory is truly awesome. And it's filled with deep emotion, The law, in theory, deals with man's justice. And that's an extremely emotive concept. The law is concerned with the human condition and with the functioning of individuals in society. It's concerned with people. And behind what appears at times to be dull and heavy text, there resides great artistry. I hope that I can share a glimpse of that with you today. By the end, what I hope to tell you is that there's not much that artists have to fear from the law of obscenity in theory. The law as it stands, as it's been interpreted, construed, artists are well protected. It's the application and enforcement which tends to be the problem with our legal system. And that's the source of the misuse. And that's certainly a cause for great concern. So what I propose to do is to now jump right in and take you through the seminal cases, primarily of the Supreme Court, that will help you understand the evolution of the notion, the definition, the application of obscenity to art and the principles surrounding it. And I will be reading out some of the discussion and findings and expressions in these judgments in the language of the authors of the judgments, because I think that will help you understand what the courts grapple with and how they think about applying the law, interpreting the law. It will give you an insight into the fact that it is a deeply emotional exercise. It's a nuanced exercise. It's an exercise which involves a great deal of thought about the human condition, about people, their proclivities, their susceptibilities, and how they fit into the legal framework. So I think it's important to try to share that, some of that with you, and give you a better sense of what at least our higher judiciary is up to. And maybe dispel some of the myths and some of the preconceptions that many of us have about the courts and what they do. So let me start with pretty much the beginning of the story in terms of the Supreme Court. And that takes me back to 1964. And of course, I'm talking about the story not of the court, but of obscenity and art, and the offense of obscenity, which is a colonial provision in our penal code, section 292, 293, 294 of the Indian Penal Code, which predates the independence of our country. So Ranjit Udeshi versus State of Maharashtra in 1964. And this involved the partners of a bookstall in Bombay called Happy Bookstall, who were convicted for selling copies of D.H. Lawrence's book, Lady Chatterley's Lover. I'm sure many of you would have heard of it. The story was of a baronet who was injured in the war and was paralyzed from the waist down, and he encouraged his wife to have relations with other men, and it caused quite a bit of stir at that time. And it's 1964 we're talking about. Obviously, the book predates that. Now, obscenity under the statute, section 292, the word obscenity was used in the provision. And if it, of course, prohibited you from selling and made it an offense to sell and distribute obscene matter. But beyond using the term obscene, the provision gave no guidance on what obscenity meant as far as that provision was concerned. Was it the dictionary definition? Was it a different definition? What were its constituents? It was not defined, and there was no elaboration. And so when the issue came up before the court had to consider first and foremost as to what obscenity, what would be the legal test for obscenity and the offense of obscenity. And the provision was also challenged before the Supreme Court in terms of its validity on the ground that precisely that it was horribly vague and subjective, and therefore lacked the necessary legal precision to be a constitutionally valid provision. It was an overly broad restriction on the freedom of speech and expression, and therefore that the Supreme Court should hold it to be invalid. And that's what the court was dealing with. Now, it's important just to understand that this was a provision that was introduced in 1925, and the context is important, and you'll realize as I go along why. It was to give effect to the International Convention for the Suppression of or Traffic in Obscene Publications, to which India was a signatory. So really, it had more to do with pornographic matter. That was really the origin of its introduction. The Supreme Court in Ranjit Udeshi's case drew a distinction, and it's important and a little troubling, between obscenity and pornography, holding that while pornography was intended to arouse sexual desire, obscenity could include matter which, while not intended to do so, had that tendency. So in other words, the intention behind the content was not relevant to the test of whether the content was obscene, even if the content was not created with the intention of causing sexual desire. If the content objectively had that tendency to do so, then the fact that it was not intended for that purpose, for a pornographic purpose as it were, then it didn't mean that it would not be obscene. So this suggested that obscenity would take within its fold more than, it was a wider notion than simply pornography, because pornography almost by definition would be intended for that particular purpose. So, I mean, that of course casts the net wider. And as I go along, I will try to show how over time the Supreme Court construed and interpreted, and there were legislative changes as well, which narrowed the net, put in certain safeguards. And according to me, and that ultimately is the thesis or the point that I want to make, obscenity as we understand it today and the law as it stands and has been construed really is something which is at the extreme end of the spectrum. And according to me, it ought to be applied only to hardcore pornography. But that could be a matter of debate. But it certainly, as it's been construed, would not and should not come in the way of artistic expression as we know it, as we are familiar with, even that which may be sexually graphic, which may be, where there would be nudity, where there would be other elements of sexuality. That by itself would not be enough to fall foul of this law. And therefore, according to me, most artists need not worry. The worry is something else, which I'll come to. Now, going back to this decision, the challenge to the validity of the provision on the ground that it's vague was rejected on the reasoning that obscenity is not a vague word, but it's well understood, even if people may differ in their attitude as to what is obscene and what is not. Now, interestingly, the same year, separately, in 1964, Justice Potter Stewart of the US Supreme Court famously wrote, and I'm sure many of you will be familiar with this or heard it sometime, about when dealing with pornography and obscenity, I know it when I see it, suggesting that it was difficult to put together a definition of it, but I know it when I see it, which is, of course, famous words that have sort of endured. And that case of the US Supreme Court involved an allegedly obscene film called The Lovers. Now, our Supreme Court, in upholding the validity of Section 292 and the offense of obscenity, relied on Article 19.2, which, as I mentioned to you in our Constitution, provides for and permits, rather than provides for, but permits the law to provide reasonable restrictions on the exercise of the right of freedom of speech and expression in the interest of, among other things, decency and morality. And the Supreme Court found Section 292 to be consistent with that exception. The court held that obscenity is always a question of degree, or as the lawyers are accustomed to say, of where the line is to be drawn. It is, however, clear that obscenity by itself has extremely poor value in the propagation of ideas, opinions, and information of public interest or profit, is what the Supreme Court said in that judgment. The court also relied on what's known as the Hicklin test of obscenity, articulated by Justice Cockburn of the Queen's Bench in an English case in which he said the following: I think the test of obscenity is this: whether the tendency of the matter charged as obscenity is to deprave and corrupt those whose minds are open to such immoral influences, and into whose hands a publication of this sort may fall. It is quite certain that it would suggest to the minds of the young of either sex, or even to persons of more advanced years, thoughts of a most impure and libidinous character. Now, this all sounds very archaic and Victorian and paternalistic, and sounds a lot like moral policing. Remember, this is going back a number of decades, and the test, as we'll come to, has evolved, and the standard has also been laid down as an evolving standard, so that as times change, the sexual mores change, community standards change, the test adapts with those changing times. It does not remain stuck in time. But yes, there was a time, and there continue to be pockets of that conservatism, but there was a time when something which we today may consider to be perfectly acceptable, not crossing any boundaries, would have been considered to be violative of the Lakshman Rekha. Now you may say, why should this be happening at all? Why should there be any moral policing? And why should the courts be thinking about or seeking, and why should the state in some way be looking to govern the moral minds of people and control the moral thinking of people and interfere in that realm? Now, it's an important question. It's a larger discussion. I don't think I have enough time today to grapple with that. It's a valid question. But what I can say is that as of now, our constitution, as I say, provides for a reasonable restriction, keeping in mind interests of decency and morality. And there certainly is an argument, and not a weak one, to be made for some degree of that inevitably taking place with our entire legal system. Ultimately, each community is different. The standards at any given time are different. And there is some sort of social contract within a particular society which is reflected in its laws and its standards of the time. Every society has that. Those standards will vary, the composition, the makeup of the peoples and the communities within that society will vary. And therefore, it can't be a one size fits all. And it is dependent on the particular circumstance of that society. And within that, there may be a requirement. You may disagree, you may feel that it should be a freer society, but that is part of a society governing itself, and that moral code does seep in somewhere. There will be some code somewhere of some kind. It may be a more liberal one, a more conservative one. Those degrees can vary, but there will be something. Now, the Supreme Court understood in Ranjit Udeshi the care that it needs to take in laying down a test for obscenity, especially considering the far-reaching implications for freedom of speech and expression. And I want to share with you how the Supreme Court viewed the challenge before it in its words. And this is what the court said. The laying down of the true test is not rendered any the easier, because art has such varied facets and such individualistic appeals that in the same object, the insensitive sees only obscenity because his attention is arrested, not by the general or artistic appeal or message, which he cannot comprehend, but by what he can see. And the intellectual sees beauty and art, but nothing gross. The Indian Penal Code does not define the word obscene. And this delicate task of how to distinguish between that which is artistic and that which is obscene has to be performed by courts, and in the last resort by us. The test which we evolve must obviously be of a general character, but it must admit of a just application from case to case by indicating a line of demarcation, not necessarily sharp, but sufficiently distinct to distinguish between that which is obscene and that which is not. None has so far attempted a definition of obscenity because the meaning can be laid bare without attempting a definition by describing what must be looked for. And this is important. It may, however, be said at once that treating with sex and nudity in art and literature cannot be regarded as evidence of obscenity without something more. And this is in 1964 that the court is saying this. So you need something more. Sex and nudity per se in art is not obscene. It is not necessary that the angels and saints of Michelangelo should be made to wear breeches before they can be viewed. If the rigid test of treating with sex as the minimum ingredient were accepted, hardly any writer of fiction today would escape the fate Lawrence had in his days. Half the bookshop would close, and the other half would deal in nothing but moral and religious books, which Lord Campbell boasted was the effect of his act. Ultimately, the court held that the test in India would be that obscenity without a preponderating social purpose or profit cannot have the constitutional protection of free speech and expression, and obscenity is treating with sex in a manner appealing to the carnal side of human nature or having that tendency. Such a treating with sex is offensive to modesty and decency, but the extent of such appeal in a particular book, etc., are matters for consideration in each individual case. The court also held that the law seeks to protect not those who can protect themselves, but those whose prurient minds take delight and secret seek sexual pleasure from erotic writings. On facts, the court upheld the conviction, and Lady Chatterley's lover didn't find favor with the court. Now, what's important is that this has undergone some change over time, this enunciation. The heart of it still remains, but there has been some change because the Hicklin test contemplated taking care of the weak-minded, those who may have a proclivity to be swayed by such material. But subsequently, later, I'll come to that, the courts have evolved a test of a reasonable person of ordinary strength and has said that, look, we can't be held hostage by the hypersensitive who is looking to take offense or who is somebody who would be drawn in a way that would be objectionable. Now, in 1965 and 69, in Chandrakant Kalyandas case, there was an appeal to the Supreme Court by the author of a short story called Shama. The story was called Shama, not the author. And it was published in a monthly Marathi magazine, Rambha. And the author was convicted for obscenity. What's important about this decision is that the Supreme Court in this decision laid down the test of contemporary community standards while testing obscenity. And it did so in the following words. And this community standards test is now what has been preferred in the latest judgments to the Hicklin test, which I indicated to you earlier. And this is what the court said. The concept of obscenity would differ from country to country depending on the standards of morals of contemporary society. What is considered as a piece of literature in France may be obscene in England, and what is considered in both countries as not harmful to public order and morals may be obscene in our country. But to insist that the standard should always be, or the writer to see that the adolescent ought not to be brought into contact with sex, or that if they read any references to sex in what is written, whether that is the dominant theme or not, they would be affected, would be to require authors to write books only for the adolescent and not for the adults. In early English writings, authors wrote only with unmarried girls in view, but society has changed since then to allow literators and artists to give expression to their ideas, emotions, and objectives with full freedom, except that it should not fall within the definition of obscene, having regard to the standards of contemporary society in which it is read. The standards of contemporary society in India are also fast changing. The adults and adolescents have available to them a large number of classics, novels, stories, and pieces of literature which have a content of sex, love, and romance. As observed in Udeshi's case, if a reference to sex by itself is considered obscene, no books can be sold except those which are purely religious. In the field of art and cinema also, the adolescent is shown situations which even a quarter of a century ago would be considered derogatory to public morality, but having regard to changed conditions are more taken for granted without in any way tending to debase or debauch the mind. What we have to see is that whether a class, not an isolated case, into whose hands the book, article, or story falls, suffers in their moral outlook or becomes depraved by reading it, or might have impure and lecherous thoughts aroused in their minds. Now, as I said, you may be, while I'm reading this, thinking to yourself, well, what's wrong with it? What's wrong with having lecherous thoughts? You can't control my mind. And is the state or the courts going to sit as a pater familias, in this patronizing way and tell us that we must not have impure thoughts, and we must not be corrupted. Isn't all this wrong? Now, as I said, there is an argument to be made for that. But ultimately, the test that has been accepted is one which has evolved and continues to evolve and contains the flexibility to adapt to changing times and a changing moral code within society. To say that there should be no moral code that the law looks at is, as I said, a discussion that somebody can have. It's a larger issue, but it's not what our constitution today contemplates. So, given the laws that we have and the framework that we have, it is something that has to be kept in mind. But the way that the courts have dealt with the concerns is to say that, look, we must make this an evolving test which doesn't get stuck in a particular conservative past. Of course, as we come to MF Hussein's case, we'll see that the court also recognizes that, in fact, there was a past that was perhaps far less conservative, and it's only a puritanical strain that has now come in and which seeks to hold all of us to ransom. So that's also part of how the issue has been tackled. Let me come quickly to K.A. Abbas in 1970, where the Supreme Court was dealing with censorship of a documentary called A Tale of Four Cities. And the court said, our standards must be so framed that we are not reduced to a level where the protection of the least capable and the most depraved amongst us determines what the morally healthy cannot view or read. So now you see that the court is shifting slowly from the Hicklin test and from catering to the adolescent and the weak-willed to now a test of an reasonable person of ordinary strength as the objective audience when applying the test of obscenity. Now, in Raj Kapoor's case in 1979, you'll remember the movie Satyam Shivam Sundaram, and there were allegations of obscenity with that movie. And Justice Krishna Iyer, who has had an inimitable style of expression, he said the following, which I thought makes for some interesting reading. Arts, morals, and laws manacles on aesthetics. He was always very flowery. Are a sensitive subject where jurisprudence meets other social sciences and never goes alone to bark and bite, because state-made straitjacket is an inhibitive prescription for a free country unless enlightened society actively participates in the administration of justice to aesthetics. The world's greatest paintings, sculptures, songs, and dances, India's lustrous heritage, the Konarks and Khajurahos, lofty epics, luscious in patches, may be asphyxiated by law if prudes and prigs and state moralists prescribe paradigms and proscribe heterodoxies. It is plain that the procedural issue is important and the substantive issue portentous. I just wanted to share this with you, though you may feel that the writing should be simpler, that this is the sensitivity that resides within the law and the issues that courts tackle. And you know, it's not that the court is not thinking about the concerns that you and I have when it comes to interfering with our freedom of expression and you know, our right to sort of to free speech. And so the courts have been sensitive, and this is all the way back in 1979 where the court was saying this. I should mention that in between, and I won't trouble you with the text of it because again, time is short, but in 1969, very significantly, Section 292 was amended, and some of the language of what was held in Rajit Udeshi as forming the content of obscenity was introduced into the provision. And so now obscenity is not just a word without any elaboration. And I'll just quickly read it out. It's now, the provision provides that that an object, and this is dealing with object like books and writings, drawings, paintings, representation, so not with performing arts, which is dealt with separately, but an object shall be deemed to be obscene if it is lascivious or appeals to the prurient interest, or if its effect, if taken as a whole, is such as to tend to deprave and corrupt persons who are likely, having regard to all circumstances, to read, see, or hear the matter embodied in it. And then performing arts is dealt with obscene acts and songs in 294, which also uses the term obscenity. So that language of depravity tends to deprave and corrupt the effect that it is likely to have in an objective sense. And the appealing to carnal desire, the pornography element, both those things were brought in to the amended provision, which now form part of the statute. Now, in 1985, Samaresh Bose's case in the Supreme Court, where the court was dealing with the alleged obscenity of a Bengali novel, Prajapati. And there's a very interesting passage which answers the question that I had posed at the beginning, which I said would be a concern that I imagine people would have, that, you know, it's all subjective. So how do you apply an objective test? How is it possible when it's all, it's per se subjective? And this is how the court describes how objectivity is to be brought in. And I'm quoting, though the court must consider the question objectively with an open mind, yet in the matter of objective assessment, the subjective attitude of the judge hearing the matter is likely to influence, even though unconsciously, his mind and his decision on the question. A judge with a Puritan and prudish outlook may, on the basis of an objective assessment of any book or story or article, consider the same to be obscene. It is possible that another judge with a different kind of outlook may not consider the same book to be obscene on his objective assessment of the very same book. The concept of obscenity is molded to a very great extent by the social outlook of the people who are generally expected to read the book. It is beyond dispute that the concept of obscenity usually differs from country to country, depending on the standards of morality of contemporary society in different countries. In our opinion, in judging the question of obscenity, the judge in the first place should try to place himself in the position of the author, and you can substitute artists. And from the viewpoint of the author, the judge should try to understand what is it that the author seeks to convey, and whether what the author conveys has any literary and artistic value. The judge should thereafter place himself in the position of a reader of every age group in whose hands the book is likely to fall, and should try to appreciate what kind of possible influence the book is likely to have in the minds of the readers. A judge should thereafter apply his judicial mind dispassionately to decide whether the book in question can be said to be obscene within the meaning of Section 292 IPC by an objective assessment of the book as a whole, and also of the passages complained of as obscene separately. In appropriate cases, the court, for eliminating any subjective element or personal preference which may have remained hidden in the subconscious mind and may unconsciously affect a proper objective assessment, may draw upon the evidence on record and also consider the views expressed by reputed or recognized authors of literature on such questions, if there be any or for his own consideration and satisfaction to enable the court to discharge the duty of making a proper assessment. Now, 2 or 3 things from this passage. Number one, this gives you an idea about how the objective test is formulated. Does it mean that it will be rid of all subjective element? Of course not. But with any decision being taken by a human being, there will be an element of subjectivity and discretion. There will be an assessment and evaluation. That's why we are not robots. And a matter like this, of whether it is obscene or not, if it's being taken by a judge, there will be an element of subjectivity. But which is why you have a hierarchy of courts, you have appeals, so that you have some safeguard and protection that if somebody has taken a patently wrong decision and allowed too much of the subjectivity to creep in, then you can have a correction of that right up until the Supreme Court. But the attempt is to provide certain tests and objective tools in terms of how to apply that. The second element which is important in what I read is that the court says, look, you may look to expert evidence, or to, if you're considering a painting, maybe you take testimony of artists or art historians about the tradition of that particular kind of art, so that you can educate yourself about what the author was thinking and what artistic tradition the author comes from. In M.F. Hussein's case, for example, I was sharing with Dr. Arshiya just before we started, I simply went to the bookshop and bought a bunch of books on art history, on ancient sculpture, on other artists who had depictions which were far more graphic sexually than what M.F. Hussein's so-called Bharat Mata painting had, and placed them before the court. The court saw all of that, and you'll see some of the passages that ultimately come in the judgment. Now, there is one more very important distinction which is critical, which was brought about in Samaresh Bose, which is the difference between vulgarity and obscenity. Obscenity in the law is a legal term of art. It is not the colloquial or dictionary definition. It is not as we ordinarily think of obscenity, as people think of obscenity. If it's deeply offensive, we say it's obscene. That's not how the definition has been understood. So merely something that offends or is you find vulgar or disgusting doesn't mean it's obscene. It is really something which is of a sexual nature primarily, which is appealing to a particular kind of interest and has, as I said, according to me, something at the extreme end of the spectrum. So the court in Samaresh Bose clarified that, saying the following: a vulgar writing is not necessarily obscene. Vulgarity arouses a feeling of disgust and revulsion and also boredom, but does not have the effect of depraving, debasing, and corrupting the morals of any reader of the novel, whereas obscenity has the tendency to deprave and corrupt those whose minds are open to such immoral influences. Some portions of the book may appear to be vulgar, and readers of cultured and refined taste may feel shocked and disgusted. Equally, in some portions, the words used and description given may not appear to be in proper taste. In some places, there may be an exhibition of bad taste, leaving it to the readers of experience and maturity to draw the necessary inference, but certainly not sufficient to bring home to the adolescents any suggestion which is depraving or lascivious. And ultimately, the court found the novel not to be obscene. I'm going to race along a little because I know that now time is not on my side. A quick decision that I quickly refer to, one decision, Sadanand's case, Delhi High Court. It's interesting because it was, you folks will remember the magazine maybe Debonair. It used to be edited by the late Vinod Mehta at the time in the 80s. And it had various pictures of nude and semi-nude women, and obviously with the intention to titillate. And the court, and I won't read out the passage, but in short, the court said that, look, I find it vulgar. I think it's in poor taste. But That's not enough for me to conclude that it's obscene. I might not like it. It's clear to me that it's intended to pander to quote unquote lustful eyes of a section of readers, but that's not enough for me to proscribe it and to prohibit it and uphold any prosecution for the offense of obscenity. So now you see the test evolving and becoming a little more liberal in its application. There's a passage which I feel is quite powerful of the Supreme Court, not directly in the context of obscenity, but in 1994 in Gajanan Visheshwar's case, when Marxist literature imported from China was seized and a petition was filed directly in the Supreme Court challenging the confiscation orders. And the Supreme Court had this to say about how democracy is to function, because ultimately freedom of speech and expression is tied in very closely with a democratic, individualistically free or a democratic society based on individual freedom. And this is what the court said. Before parting with this case, we must express our unhappiness with attempts at thought control in a democratic society like ours. Human history is witness to the fact that all evolution and all progress is because of power of thought, and that every attempt at thought control is doomed to failure. An idea can never be killed. Suppression can never be a successful permanent policy. Any surface serenity it creates is a false one. It will erupt one day. Our constitution permits a free trade, if we can use the expression, in ideas and ideologies. It guarantees freedom of thought and expression, the only limitation being a law in terms of clause 2 of Article 19. Thought control is alien to our constitutional scheme. To the same effect are the observations of Robert Jackson Justice in American Communications Associations versus Dowds with reference to the US Constitution, where the judge said, thought control is a copyright of totalitarianism and we have no claim to it. And I find the next part particularly compelling. It is not the function of our government to keep the citizen from falling into error. It is the function of the citizen to keep the government from falling into error. We could justify any censorship only when the censors are better shielded against error than the censored. See how powerfully that's put, and our courts have been sensitive to jealously guarding the freedom that we cherish and which is embodied in our constitution. I should just mention, for the sake of completion, that in Avik Sarkar's case in 2014, the Supreme Court held that the Hicklin test is the wrong test and preferred a community standards test. And I'm going to just take a few moments and I will conclude very quickly by reading out just a couple of passages. I've run out of time, of what the court said in M.F. Hussein's case in 2008, while quashing the prosecutions against him, which were initiated for the so-called Bharat Mata painting, which Alka ji will perhaps show a little very soon, which had a lady who was depicted in a pose where she sort of outlined the map of India, and she was in the nude. And it was there was nothing graphic about it as such, but she was in the nude. And there were various complaints filed all over the country. And we went to Supreme Court, had them consolidated, brought to Delhi High Court, and then challenged them. And ultimately, the High Court quashed it. Just a couple of passages, and then I'll stop. The judgment begins with the following quote from Pablo Picasso, saying, "Art is never chaste. It ought to be forbidden to ignorant innocents, never allowed into contact with those not sufficiently prepared. Yes, art is dangerous. Where it is chaste, it is not art." So that was what the court kept in mind as the opening words and the theme of its judgment. And ultimately, the court said, and I'm just picking out
Mr. Sibal,
one
I
or
just
two
need to
things.
add one thing that
Yeah,
we finish this normally at about 8:15.
yeah,
So if you
all
could
done,
just
all
wrap
done.
it up, then
So
otherwise Dr. Pande will have a
absolutely,
problem.
absolutely. So I just two minutes literally. Number one, the court said the test for judging a work should be that of an ordinary man of common sense and prudence, and not an out of the ordinary or hypersensitive man. And it is also clear and apparent that the criminal offense of obscenity is predicated upon the legal term of art, and that the legal test of obscenity cannot be equated with the dictionary definition of obscenity, which takes within its fold anything which is offensive, indecent, foul, vulgar, repulsive. In legal terms of obscenity, the matter which offends, repels, or disgusts does not tend to deprave. And just I'll skip the rest. In short, the court concluded by saying it is most unfortunate that India's new Puritanism, and this is after discussing what the art, the ancient art in India, and the depictions, the graphic depictions at time in that art and sculpture. The court says it is most unfortunate that India's new Puritanism is being carried out in the name of cultural purity, and a host of ignorant people are vandalizing art and pushing us towards a pre-Renaissance era. So I'll close with that. Extremely sorry to overshoot the time. I think I just got a little too passionate about it, but thank you. Thank you so much.
Quite understand why you're so passionate about it. And thank you so much. Even the judgment did not refer to so many cases that you have referred to today. So for those of us who will read the judgment and then listen to this talk, it's been a totally enriching experience. Thank you. Without further delay, I'm going to request Dr. Pande to speak. She has a few slides and she will speak on those slides. So, which also includes the famous Bharat Mata image. Alka, maybe you would like to connect with the slides or whatever. Incidentally, the painting was never called Bharat Mata. It was a name that was given to that painting by, guess who? The auctioneer. So the story is a lot more nuanced and convoluted than what appears. Dr. Pande, thank you for your
Let me
patience.
begin by thanking Arshiya for putting such a wonderful set of, 5 series on art and laws. It was delightful to hear Akhil Sibal. In fact, he has covered almost all the points in a very beautiful manner, and I will forgive him for overshooting time, not because of his passion, but the wonderful quote of one of the most powerful and most influential artists of modernity, Pablo Picasso, when he said that art is not for the chaste, and neither is it for the weak-kneed. Of course, certain keywords which I would like to hear, quote, or use is Section 292, obscenity, literature, progressive writers, Hicklin test, Roth test, all the points which Akhil has beautifully quoted and referred to, given all the judgments, very, very important judgments, Lady Chatelet's lover, talked of obscenity, pornography. I would just like to actually uh, refer to two important things which form the basis of obscenity is the word nude and naked. And for this, I want to go back to Kenneth Clark when he opens his classic study of the nude and how he very clearly says that the word nude carries in educated usage no uncomfortable overtone. In fact, to be naked is to be deprived of our clothes, and the word implies some of the embarrassment most of us feel in the condition. But in the greatest age of painting, the nude inspired the greatest works, and even when it ceased to be a compulsive subject, it held its position as an academic exercise and a demonstration of mastery. So the nude actually becomes a tool of artistry and of artistic expression. And in fact, most art schools begin by doing still life drawings and understanding the human body, the nude body. I mean, there is no word obscenity, which can go into it. And as Akhil has very clearly pointed out, and looked at also pre-modern art, where in the external facades of Khajuraho, of the Lingaraj temple, every aspect of human life is shown, from same-sex coupling to bestiality to mithuna to maithuna, all these things which have been seen. And I actually want to go back to an example and problems which I faced. I did an exhibition called the Kama Sutra in the City of Love in Paris. It ran for 4 months at one of the most posh museums there called the Pinakothek. And could you believe that I could not take any miniature paintings from this country to show in the museum in Paris? Because there was this whole thing of the association of pornography. It was not even obscenity. Miniature paintings came into the whole umbrella of pornography. When I went to Sultan Singh Bakliwal's daughter, he has some of the finest collection of what we call erotic paintings. He told me that much as he would have loved to loan the work to the museum, he couldn't do so. And all the work I had to collect was from museums around the world. And the miniature paintings I got from the Rietberg, I got from the Musée des Beaux-Arts in Brussels, but I couldn't take any of the really erotic works from my country to show in Paris. I wanted to show just 6 slides actually, while Akhil has given the entire background and the legal framework and the sensitivity and the wonderful judgment which was done by Sanjay Kishan Kaul when he kind of absolved all the cases against Hussein. I just want to show you these 6 slides very quickly. The only thing is, Arshiya, would you ask him to put the slides? Yeah. So now I would like to, my opening slide is that of Marcel Duchamp's fountain. Can we have the slide? Or I don't know if I can use it. Can you show the next slide, please? Yeah. Yeah. So this is the fountain, a common variety of a porcelain urinal that Duchamp showed in an exhibition in New York in 1917. And he used the pseudonym called R. Mutt. Now, this work caused a huge scandal with people calling it vulgar, immoral, and indecent. Some even claimed the piece had 0 artistic merit. But in spite of its initial reception, Duchamp created a new definition of what was called conceptual art, changed the meaning of modern art forever with this piece by using a ready-made object instead of painstakingly creating the work with his 2 hands. Duchamp invented this whole thing of what we call conceptual art. Next slide. I wanted to, in fact, Akhil has already mentioned a lot of people of literature. I want to talk of Sadat Hasan Manto, he had actually 6 cases of obscenity for his short stories, 3 in India before 1947 for Dhuan, Boo and Kali Shalwar, and 3 times in Pakistan after 1947 for Khol Do, Thanda Gosht, and Upar Niche Darmiyan. Now, under Section 292 of the Indian Penal Code and the Pakistan Penal Code in Pakistan's early years, a book or writing would be considered obscene if it is lascivious or appeals to the prurient interest of its effect, if taken as a whole, such as to tend to deprave and corrupt persons who are likely, having regard to all relevant circumstances, to read, see, hear, or hear the matter contained or embodied in it. Now, Manto also managed to get out of the obscenity cases But he was fined for one case, of course, and these charges of obscenity haunted him. And all the time, till his death, he said, I'm not a pornographer, but a story writer. Next, I want to show you the image of image of a couple, a very intimate couple. This is an image by Akbar Padamsi. In 1954, when Akbar held his first solo at the Jahangir Art Gallery, some viewers were very, very upset by the content of these paintings. The painting showed intimacy of couples. They were nude. Yeah, I'm saying the word nude because nude is very different to naked. And the city police ordered the removal of the paintings, but Padamsi refused to comply. A charge sheet was filed against him for obscenity. He was arrested, granted bail the same day, May 2nd, 1954. The Esplanade Court, which heard the case, ordered that the paintings be returned to the artist on the condition that he did not display them in public spaces. However, he could display them in his private places. Now, the next painting, which I want to show, is the iconic painting which Hussein painted. And of course, as Arshiya rightly pointed out, the name was given Bharat Mata by the auctioneer. Suppose the auctioneer had not given the name Bharat Mata, I wonder if this case would have been what it is. Now, if you see that the advertisement of the painting led to protests and private complaints were filed in various parts of India. The Supreme Court consolidated and transferred the matter to Delhi. I don't want to talk too much about it because Kapil is a better expert at that. I'm only talking of the point how sensitive the judgment was when the judge said, don't forget to mention that the very concept of the lingam, which represents Shiva, resting in the center of the yoni, is a representation of the act of creation, the unity of Prakriti and Purush, adding that the ultimate essence of a work of ancient Indian erotic art has been religious in character and can be enunciated as a state of heightened delight or ananda, the kind of bliss that can be experimented only by the spirit. Now, the objectionable painting by Hussein was advertised, of course, as Bharat Mata. So that's another aspect to it. Suppose it was not Bharat Mata, as I kept saying, I wonder what the case would there have been a case. Now, again, showing the poster of PK. Next, please. This is very, very interesting, changing norms. This is the first poster of Amir Khan and Rajkumar Hirani's PK, where you see the actor standing on a railway track, absolutely nude, with only a transistor to cover his modesty. Now, the Chief Justice, R.M. Lodha, who headed a 3-judge bench and heard a PIL against the film, said, and again, very sensitive, let art remain art. We do not understand how public order is disturbed by it. If you don't like it, don't watch. Please show some tolerance. We cannot take away the public's right to watch a movie. I want to show another case and talk of another case. This is about literary merit. Can we have the next slide, please? It is Perumal Murugan. This is his novel called Madhoru Bhagan. This was when you translate it, it's called One Part Woman. And Perumal Murugan there was a case filed against him in the Madras High Court on July 5th, 2016. And the judgment has received wide appreciation for its support for the freedom of expression. The book was actually, or the story was about a married couple, Kali and Punna, who fall in love, who fail to have a child despite many years of marriage. They succumb to social and family pressures to allow Punna, the wife, to participate in a sexual orgy, unrestrained sexual encounter involving many people in a religious festival. So you see, in India, the spiritual and the erotic do go hand in hand. And this is the land of the Kama Sutra. Where does the Kama Sutra come? If you listen to the tales and the parables and the stories, it comes from the intense love making of Shiva and Parvati, who are the primordial parents, the Jagata Pitaru Vande Shiva Parvati. Now, this couple, Punna and the wife Punna, goes and participates in a religious festival which takes place in an Ardhanarishwar temple for begetting a child. Now, who is Ardhanarishwar? Ardha Nari Ishwara, the Lord who is half woman, and the deity is Shiva and Parvati conjoined in one image, which is that of Adbhuta, of wonder, of awe. And here you see poor Perumal is charged with obscenity. And what was the court said that there are different kinds of books available on the shelves of bookstores to be read by different age groups from different strata. If you do not like a book, just close it. So this actually reflects an extremely progressive view of the judges on sexual morality, on reservations, on the all the reservations we have on the court's reliance on ancient literature to justify why sex and its depiction in art or literature is not obscene. And as Akhil said, when he was talking of the Hicklin rules, how they are changing, things are changing. And what we were bound, basically by the very punitive Victorian prudery, where you even have the piano legs covered when you look at the history of sexuality of Michel Foucault, where the sandwiches are also covered because they're cut through the center. So, within the Indian context, when we even look at bhakti or Riti Kaleen poetry, there is explicit, representations of copulation, of enjoying sex. They were never looked down upon. Even when you look at the Gita Govind, when Jayadev is talking of the love of Radha and Krishna, and when you look at the love bites, or when he's writing on Radha's breast, did anybody make a noise? So all these things which changed, which were translated, transmuted over a period of time, and I think the worst the most, I would say, the most double-faced, perhaps I should use the word, was in the time of the rule with our colonial masters, and some of the laws which were passed were extremely out of context with the culture of the country in which they were made. So I know Arshiya wants to end at 8:15 and it's already 8:18. I'll be happy to take questions. I would like to just show two more slides if we could. The next one, please. No, this is my last slide. Okay, fine. This is my last slide. So I'll be happy to take questions, and I can, talk of my other points as we handle the questions.
Thank you very much, Alka. It's sort of, the words and the images have come together. And there are many questions that are in my mind, but I will put them back because I'd like to bring up some of the questions that the participants, those who are attending this webinar, have sent to me. And interestingly, Akhil, you mentioned that judges have this element of subjectivity, which was also addressed in, I think, the case that you mentioned, the Bose case, I think that you mentioned. But I have one participant who is asking me, apart from the artist's rights, would censorship in law, which means banning any particular artistic work, not affect the rights of adults, individuals as consumers of any art form, especially avant-garde art? And the suggestion is, shouldn't the law simply prevent non-adults from accessing certain complicated things rather than completely banning it? Because the banning it is an assault on individual rights. So this is the question, the first question that I would like to ask you.
Yeah, so I mean, I tend to agree that banning things only fuel interest in that which is banned. So it usually has the opposite effect of wanting to keep it out of people's hands. But for instance, there are um, some forms which can be regulated. So for instance, with movies. So prior censorship has been upheld, though it was challenged, saying that look, the movie form is can be a very highly influential form, and so movies get ratings, and so there is some regulation where there's an adult movie or fit for an adolescent, but one may not be able to do that for everything. If a book is readily available, if there's an exhibition, generally one doesn't have an age bar on who's to attend and so on, and uh, there's not a censor board, and those things don't go through prior censorship at all, and there's no certificate. And in fact, one would not want that there is certificates for any art form. As I said, it was contested even for movies, and we know how censor boards act and how they tend to be political. And a lot of the case law in the Supreme Court has been because of censor boards, and the for instance the Phulan Devi case, that Shekhar Gupta movie, Bandit Queen, that came up before the Supreme Court. It's a beautiful judgment on a sensitive one on how, and there's a scene in that for 2 minutes where she is in the nude, and so somebody challenged that, and the Supreme Court said, look, this is certainly far from anything obscene, and it's contextual, and it's with purpose, it's with message, and in fact, this is something that we cannot deprive people of. So it is a bit tricky, but the point is that doing away with all regulation and just expecting that people will consume that matter responsibly, I don't think our society is ready for that yet. As a society, I may be, but our society as a whole, I don't think our community standards are there yet. So we are a little bit behind in terms of degree.
In fact, interestingly, in the Bandit Queen case, the court cited the example of Schindler's List and said when all those people were being in the nude marched off into the gas chambers, what was the rasa that it was evoking? What was the feeling it was evoking? So I think it's not just intentionality, but also what is it meant to evoke in you? You can't just take things out of context. So thank you. And sorry, just a little pointer. You know, this film certification, which censor board, is actually just a certification board, much like cigarettes that cannot be consumed till you're 18, or alcohol that cannot be consumed at different ages in different parts of India. It's merely just a certification thing. But in cinema, you can control entry. What do you do with the internet? Do you police it? It's there in everybody's home, right? So, Alka, can I ask you one question, please? I was shocked and surprised to hear your reference to the fact that the miniature paintings were not, you were not allowed to take them out because that came in pornography. Now, was it only the erotic paintings that came in pornography, or is that normally the rule? And if it is only the erotic paintings, what constitutes erotica? And I know you're quite the champion on that with your book.
I too was surprised, Arshiya, because you have the Nayak Naika, you have the pleasure albums which have been done. You have even the Ragamalas. In fact, if you see the Rajasthani Ragamalas, the Kangra, some of the Ashtanaikas which have been painted, for example, or even the Gita Govind. These are the paintings I'm talking about. I'm not talking of the whole gamut of miniature paintings. Anything, because I was curating something which was very, very specific related to the Kama Sutra. So I was showing the different rasas, even the rasa of Shringar, where the Nayak and the Naika are in close embrace. You see, the thing is that these are very outdated rules which were set up by the colonial masters. Unfortunately for us, culture in our country is always treated as somebody else's orphan child. And people also, we have many other issues which I presume are far more important, like public health, drinking water, poverty alleviation. But the point is that nobody looks at these outdated rules which are there. So when you go through the Department of Culture, and they are supposed to evaluate, they are supposed to value the work of art, they just say ये तो pornography है, ये तो जी मैडम आप ले ही नहीं जा सकते. So this is the thing, that we in our own country are not really clear about what is pornography. In fact, just wanted to quote a very, very interesting thing on the nude figure, which was very interesting, said by Christine Gregory. Naked is being vulnerable, while unclothed may be trying to cover up. Male nudity shows power. Female nudity shows sexuality. So here also there is a huge gender bias. So when you see, you see the case which Akhil was referring to, the Avik Sarkar case, it showed that, I'm forgetting the name, I think it was a tennis couple shown naked, the fiancé shown naked. Boris Becker and his fiancée, they were shown naked. So how is that to be a obscene case, may I ask? If the couple themselves are happily showing themselves in a naked form and they are not even feeling, it's not even a case of artistry, it's not even a case of a nude, but they are happy. So why should anybody react to that? In the same way, there is no clarity within our structure. What is pornography? What is erotic? Is the erotic related to the spiritual? Because if you look at the entire range of what we call erotic in the spiritual, whether it's the Ragamala, whether it's the Geet Govind, whether it's the Naika series, they are all deeply layered and spiritual. Yes, the pleasure albums which were done for the rulers, most rulers got artists, and in their ateliers, they got pleasure albums of the Kokashas, the Kama Sutra, the 64 asanas. There's so many of those khakas, or even if you look at the Nath Dwara miniatures, they are full of absolute copulating couples. They are pleasure albums. There was a clear delineation in medieval period, what is for pleasure, what is vilas, and what is ananda. There's a big difference, and they come both under the umbrella of Shringar Ras. One end is the Rati Bhav, which comes under Shringar, and also Vilas, which comes under Shringar, also Ananda. So as you see, if you look at the Dhwani of each of the rasas, they have different connotations. So it's up to the viewer, as all the judgments say, let the viewer decide. And the viewer, or the Rasika, or the consumer of art, whether it's literature, dance, or painting, let them decide. If they want to ingest it, fine. And the thing is, talking of the weak. Who is weak? If the brain is weak, then you please stay at home. Nobody is forcing you. But even today, at the Habitat Center, we had to close down a couple of shows because people came with hockey sticks to beat up people and saying, "Ye to aap ashleel cheez dikha rahe hain." Now, who are the custodians? Who are the gatekeepers? Can a law actually, the very point that you said, can anything be banned? So these are very, very gray areas, extremely nuanced, extremely delicate, and have to be dealt with absolute empathy and sensitivity.
So in a cultural scenario where our texts talk about auchitya, or you judge for yourself what is appropriate, a Milind Soman can run in the nude, and that is aesthetic. His pictures are taken at that time. That doesn't seem to cause any social disorder and stress in society. And yet a painting...
What about David by Michelangelo in Rome?
Yes. No, I'm just trying to locate things in India, just so that to be able to get to it. And
But
all
he had a case
around,
filed against him, though.
really?
Yeah,
Now?
yeah. After that picture, the police registered a case against him.
Oh dear.
So many years ago, we had a very well-known dancer, but this was before her dancing avatar, I think, who was supposed to have streaked in the streets of
Yeah.
Mumbai. She actually did not. She was on a beach in Goa. They just did whatever they do with photographs to make it look as if it was a street in Mumbai. Pratima Bedi, now the late, no more with us. So we do have a tradition of streaking as well for artistic purposes. Yeah, I don't know. There is a question that I think Uttara is trying to ask, but she's messaging me saying my video is muted. Type it in, Uttara. I'll say. All this is not very, very easy for me. Uttara, if you can hear me, I just want to tell you that you can type in your question, please. The video, I don't know why it's off. I had suggested that you put.
You'll have to
Yeah.
unmute it on your screen.
If you want to speak, it's not happened before, but try and unmute it. Maybe you can speak. Okay, let me just check. I'm sorry. This isn't. So people might be curious to know what is the next step. Yes, Uttara. Now, if you were to just try and unmute your mic, we may be able to hear you, or you type. Can you hear me? Yeah, okay.
Don't interrupt your meeting. Please continue.
Anyway, what was I going to say? Yes, people might want to know what's next because this is the last of the series. So in the initial document, when I wrote it to the Visual Arts Gallery, the co-producers of this program, we talked about bringing out a book. So that is our plan eventually. And all of you who have been gracious enough to share your thoughts, I hope you will permit us to transcribe what you said, get it approved by you all to include it in a book. Uttara, are you okay now?
Yeah.
No? Yeah.
Yeah.
No questions? All right. Let me just see then if there's still anything that I need to please. No. So thank you very much, all of you, for being participants in this program, the last in the series. I'm going to miss you. I'm going to miss putting it together and the madness that used to accompany the day before and the day of the program. But it's been an absolute pleasure. I have made so many wonderful friends. I have heard such brilliant addresses like today's, for instance. And I just want to hold on to it, which is why we are looking at the book. And I look forward to all of you joining in that book enterprise and thereafter in reading. Arts and the Law will continue. The artsandthelaw@gmail.com will continue to be alive. So please, if there are any thoughts, let us share them with us. And we would love to know what else you think we should be able to do. People do suggest that there should be a part 2, but I think the part 2 should be contained in the book. Okay. Thank you very much. Thank you, Mr. Sibal. Thank you, Dr. Pande.
Thank you so
And
much.
guys, thanks a lot for being.
Thank you, Akhil. It was a lovely,
Thank you.
lovely way of being together and sharing.
Yeah.
Thank you.
Thank
Bye.
you. Bye.
Thank you.